Welcome to this presentation, Current Issues in Leasehold Conveyancing, a Roundup by myself, Stephen Desmond, brought to you with MBL seminars. For those of you who haven't been on one of my leasehold courses before, this is just one of several courses that I run with MBL that specifically pertain to long leases. And the issues that we're going to cover in this presentation today will encompass service charges, alleged breaches of leasehold covenants, such as repair and insurance, the thorny issue of whether the lease clearly defines the extent and the scope of the demise, alienation covenants, including restrictions on subletting, unauthorised alterations, roof space and roof balconies. Also, you might be surprised that this has been added in, but selective licensing and additional licensing. And I'll explain towards the end of the presentation why those specific issues have been included in the presentation. My first port of call is on service charges, and this concerns the case of Craghead versus 96 leaseholders. In this case, an application was made to vary the long leases of 96 flats. Now, how can you do that? Well, in certain cases, if you have the requisite majority support amongst the leaseholders, application can be made under Part 4 of the Landlord and Tenant Act 1987 for a whole number of leases, for example, on a single development, to be varied to more or less similar extent. The problem, though, in this particular case is not focusing on the process of variation, but just to focus on what the problems were with the original lease. As the leases were all in standard form, they originally didn't contain any comprehensive provision requiring the landlord to keep the whole of the reserved property in repair. This included the external parts of the building or to recover the costs.